Healthcare policy was a big topic in the presidential election. As John Yang reports, the Affordable Care Act was back at the Supreme Court today with insurance coverage for tens of millions of Americans at stake. And then William Brangham looks at what faces President-elect Biden.
You want a little bowl?
Nicole Stoll is at high risk for breast cancer because of her genetic profile and family history. But the mother of 5 and small business owner wasn't able to afford regular MRIs until January. That's when she qualified for Medicaid for the first time under a provision of the Affordable Care Act, or Obamacare. The screenings have turned up spots, but not cancer so far.
The fact that I'm able to go back in every 6 months right now and get some peace of mind, and also just make sure that it doesn't turn before I'm able to get my preventative surgeries. That obviously is a huge weight lifted.
That relief is under threat. Today, supporters of the ACA rallied outside the Supreme Court as 18 Republican-led states and the Trump administration asked the justices in a conference call oral argument to overturn the entire law. That would threaten insurance coverage for more than 20 million Americans in the midst of a pandemic. The opponents say that in 2017, when Congress eliminated the penalty for not buying health insurance, it made what's called the individual mandate an unconstitutional command because it says Americans shall buy qualifying policies. Liberal Justice Stephen Breyer challenged that argument by evoking family dynamics with Trump administration Acting Solicitor General Jeffrey Wall.
Have I ever said, or have you ever said to someone in your family, you shall do it, but that is an entreaty. An entreaty, or a supplication, rather than threatening a punishment.
No, Justice Breyer, in my family, when I tell my kids that they shall do things, that's a command backed by a penalty.
The law's defenders say that without the penalty, the mandate is meaningless and therefore not unconstitutional. New Justice Amy Coney Barrett questioned California Solicitor General Michael Mongan.
You're asking us to treat it as if it functionally has been repealed, but that's not what Congress did. Does that matter?
Your Honor, I think Congress understood how this court had construed 5000A as a choice, and it understood that it would make the provision effectively inoperative to zero out the tax.
The opponents say if that provision falls, so should the entire law, because when Congress passed it in 2010, lawmakers said the mandate was key to making it work. But former Solicitor General Donald Verrilli, defending the ACA, said experience has shown otherwise.
There were generous subsidies to draw people into the market, and it was easy to enroll because of the exchanges. But there was also a stick, the tax payment if you didn't enroll. And I don't think there's any doubt that the 2010 Congress thought that stick was important. But it's turned out that the carrots work without the stick.
Even some court conservatives, like Chief Justice John Roberts and Justice Brett Kavanaugh, sounded skeptical of the opponent's argument.
I think it's hard for you to argue that Congress intended the entire act to fall if the mandate were struck down, when the same Congress that lowered the penalty to zero did not even try to repeal the rest of the act. I think, frankly, that they wanted the court to do that, but that's not our job.
It does seem fairly clear that the proper remedy would be to sever the mandate provision and leave the rest of the act in place.
Marcia Coyle is Chief Washington Correspondent for the National Law Journal.
If you have the Chief Justice and Justice Kavanaugh believing that there is a way to save the act, even if a majority of the court were to find that what Congress did in 2017 resulted in an unconstitutional mandate to buy health insurance, that they joined with perhaps the court's 3 liberal colleagues who also seem to think similarly, would be able to sever or cut out that mandate.
The Affordable Care Act was President Barack Obama's signature domestic achievement. Among its most popular provisions, prohibiting insurance companies from refusing to cover pre-existing medical conditions, like Julia Ray's diabetes.
Diabetes is actually a killer. People die from diabetes, uncontrolled diabetes. There are points in time when I was at 600. 2 weeks ago, I was at 28. Either of those can send you into diabetic coma.
We first met Julia and her son Charles in 2015 when another Supreme Court challenge threatened to subsidize insurance she purchased on an ACA marketplace. 2 years later, congressional Republicans nearly succeeded in repealing the law. Ray, an auditor, now gets insurance through her job, but she credits her previous ACA coverage with stabilizing her health and her career.
Cutting out pre-existing conditions and shutting off these types of aids, this may curtail a person who is working their way into a viable position that will enable or help the economy. I don't know why this keeps coming up. It's almost like we don't care about our people.
The court's ruling is expected by next summer. For the PBS NewsHour, I'm John Yang.